Okay, hi everybody. My name is Chris Sprigman. I teach here at the law school. I teach intellectual property courses as well as antitrust. And I'm here to moderate the panel on what we've kind of shorthanded as the Microsoft case's economic infrastructure. So entry barriers, network effects, switching costs, raising rivals cost strategy, all in the context of platforms, and this was, as has been noted in the previous panel, an early platform case. And these economic concepts, we want to look back at them and talk about how they work their way out in the Microsoft case, and then we want to think about how they've been applied ever since. And to do that, we have some people here who have been some of the sharpest thinkers about these issues, and also one person who was there very much from the beginning, helping gestate these ideas. So I'm gonna just give the names and titles of the folks who are gonna talk with us today in order. At the end, I'm gonna, when they've all said their piece, I'm gonna ask some questions, encourage them to interact one with another, and then try to leave significant time. Since this is such a great expert group of people, I wanna get your questions as well. So starting us off will be Steve Salep, who's a professor emeritus from Georgetown Law School, great academic economist that you probably all know. Next will be Dan Rubenfeld, the Robert Bridges Professor of Law and Professor of Economics Emeritus at UC Berkeley and Professor of Law Emeritus here at NYU. Next will be Eric Hovenkamp, Professor of Law at Cornell University. And finally would be Michal Gal and Raz Agranat. Michal is professor and director of the Center for Law and Technology at the University of Haifa, and Raz is a JSD candidate at the University of Chicago. I'm just gonna take a moment for a little moderator's privilege and say that my position here really comes from the fact that I was the junior appellate lawyer on US versus Microsoft. I was the guy assigned by the appellate section to go look at the trial every day and make reports and make sure we understood what was going on. So I got as a very young lawyer, I got a real close-up view of some of the best lawyers that I had ever seen then and still who hold up as the lawyers I have seen since, in terms of their both lawyerly acumen and their technological and economic sophistication. It was a real immersion for me in something that I really value about the antitrust community, which is its great intellectual flexibility and depth. So with that, I want to turn things over to Steve to start us out.
Okay, thanks. In my 8 minutes, I've been asked to get through the concepts, so I'm going to do that very quickly. I've got a couple slides so that you can replace, I can replace my talking with your reading. So starting with the network effects, there were these concepts that were developed, early paper on network effects in the 70s, and then the big work was done by what I call the big four. Carl Shapiro, Mike Katz, Garth Saloner, and Joe Farrell did fabulous work on network economics in the 80s and early 90s. Garth Saloner co-authored the white paper for Netscape that went to DOJ and really educated them initially about Microsoft's conduct. So the ideas are really simple. I mean, network effects are demand-side economies of scale. There can be what we call direct network effects, which is like a communication platform or social media. And then indirect network effects are the things like, well, more people using Windows OS will lead more developers to produce applications for Windows, which will cause more people to want to buy that OS. So the virtuous circle from the feedback effect. When there are network effects, there can be switching costs from one network to another, and that's a barrier to entry. That's going to be the applications barrier to entry in Microsoft. But you don't have those switching costs if the networks are fully interoperable. So interoperability is the extent to which the products in one ecosystem or one platform work well with one another. And then middleware is the software that facilitates interoperability. So let me show you a couple of slides from that period of time that indicate, although it was in the economic infrastructure, how hard it was to explain it to non-economists. So here's the way, this is from a paper I wrote in 1998 about how you explain interoperability and the application's barrier to entry. So, and hey, they had to teach this to me as well. So we learned that it was like a jigsaw puzzle or Lego pieces that they fit together. So Lotus 1, 2, 3, it would have to completely reprogram itself, porting as they called it, to work on another operating system. But then what middleware could do is eliminate the application's barrier to entry. So without the middleware, an application would either be written for Windows or for the rival operating system. If they'd want to write it for the rival operating system, they'd have to start all over. But with middleware like Esperanto, you could just write it in the middleware language, the APIs from Java and Netscape, and then they would translate it. They had a translator, a Java virtual machine or Netscape APIs that would make it work for Windows or make it work for the rival operating system. So the idea, the Java slogan was write once, run everywhere. That was very primitive, and so the other slogan was write once, debug everywhere. So those were the basic concepts. They're all over, of course, the Microsoft opinion with the application's barrier to entry. So what middleware was going to do was eliminate the application's barrier to entry. Eventually, Daniel Francis would say, but what Microsoft did was it destroyed the middleware threat and maintained the barrier to entry, which naturally allowed it to maintain its monopoly. Okay, so there were these other set of concepts from industrial organization that I want to talk about that are also, were more, actually, I think they were more implicit in Microsoft. They're actually much more noticeable in the district court opinion than in the appellate opinion. In fact, in many ways, I think the district court opinion's better. Had he only not chosen to talk to reporters every afternoon, it would have had a lot more weight. So the first concept I want to talk about is raising rivals' costs. Let me go back to the earlier slide. So raising rivals' costs, rival counter strategies, and the first principles approach. So raising rivals' costs, my best slogan ever. Microsoft was a raising rivals' cost case. I mean, by excluding middleware, what Microsoft would do is maintain the application's barrier to entry by raising the cost of rival operating systems. And the way they were going to do that was by raising the cost of distribution of the middleware. So it was kind of it was two steps, a double inference, Andy Gavel would call it. So they tried to raise the cost of middleware with threats and exclusives. Well, when you have the monopolist paying people to distribute Internet Explorer exclusively, then a Chicago economist would say, hey, that's just competition for distribution. Why doesn't Netscape and Java, why don't they just pay the OEMs more? That's the way the market works, just competition. And the error in that, Microsoft made that argument too, and the Chicagoans make that argument. The error is to assume that competition for distribution is going to be on a level playing field. And there are lots of reasons why that's not going to be true. Very often, for example, a monopolist will sign exclusives even before the entrant comes on the scene. So the entrant never even has a chance to bid, and there's coordination issues and so on. But the most important economic concept that's left out of the Chicago School argument is that the bidding's not on a level playing field because the stakes are asymmetric. And this is an issue that Rich Gilbert and David Newberry originally brought into the literature in the late 70s and early 80s. And I've got a little picture to help explain it to you, because this is one that all second-year law students should understand and isn't taught in most places. So the idea is the monopolist and the plaintiff are bidding for distribution. If the plaintiff wins, he's going to compete and there's going to be a duopoly, and you can see the profits there, and total duopoly profits will be 160. If the monopolist wins, the the plaintiff is nascent entrant, he's going to be stuck at a very small position, and you can see the monopolist will make a lot more money. Well, under those circumstances, in a bidding war, the monopolist would be willing to pay up to 100, which is what it gains from deterring entry. The entrant is only willing to pay 40 because that's how much he gains in a duopoly market. And so the monopolist wins the bidding. And it turns out these numbers don't matter as long as monopoly profits exceed combined duopoly profits. The monopolist will win the bidding. It's a fantastic, fantastic result. If on the other hand, duopoly profits were higher, then the entrant would tend to win. And so this idea, this is why you can't count on counter strategy. This is why competition for distribution is not true pro-competitive competition. The last idea that I want to talk about is what I call the first principles approach. And this one's really crucial for Microsoft. And the idea that you can see from the slide is that monopoly power and exclusionary conduct, the two elements of Section 2, are historically treated as two separate issues that you look at sequentially. And if the plaintiff can't prove monopoly power, then the case ends. And the error, the reason why you should look at power and conduct holistically in tandem is that the exclusionary conduct may actually be the cause of the monopoly power, not just the evidence of it. And so that's where the cellophane fallacy came from, is they analyzed monopoly power in a vacuum without taking into account that DuPont already had a monopoly, and so it didn't have an incentive to raise the price any higher. And this is the cellophane fallacy named after the Supreme Court. But the other kind of error is that if you have, say, a monopolist with monopoly power, and this is actually, I'm hesitating because I'm kind of leaving out a step. Disconnection number 2 was Microsoft's argument. They said there are no barriers to entry. If you wanted to do market definition, our market share would only be 10% if you did it right. And since we have no entry barriers, you should dismiss the case. And of course, if you dismiss the case, then we can destroy all the people that we said were the entrants. It was totally wrong, just totally wrong. And how is this analyzed in the, and so what I call the first principles approach is that you ought to look at them holistically. The DC Circuit didn't embrace this argument. They missed the opportunity. I've got the language here. The circuit court said, well, they had monopoly power because they had a 95% share. The district court said that there was other evidence consistent with monopoly power. One is they priced without reference to what other people were doing. And then secondly, their pattern of exclusionary conduct could be rational if the firm knew that it possessed monopoly power. So the DC Circuit said we're going to use the conduct as evidence of monopoly power. But they didn't get at the point that it was the cause of monopoly power. And the district court had that part. The district court said Microsoft has comported itself in a way that could only be rational for a profit-maximizing firm if the firm knew that it had monopoly power. And that's the part that DC Circuit took. But then they also said, and if it was motivated by a desire to preserve the barrier of entry, protecting that power. So Microsoft missed that opportunity to bring this, to connect cellophane. It's in Kodak. It's why the ISOs were willing to win Kodak. They could have brought that into the law at that point, but didn't.
Okay.
Thank you.
Thank you. Dan.
Thank you very much. I want to start off by giving comments about that come from an article I wrote a year ago in the Antitrust Bulletin, in which I argued that the Microsoft case would be adjudicated the same way it was 25 years ago, even though Amex requires an analysis of a world in which there's a two-sided market. And there is a two-sided market here. You've got customers who use Windows on one side of the market, and you have the developers developers on the other side of the market. And when you think about those two sides of the market, almost all the analysis would apply. There clearly are network effects on both sides of the market, and that makes sense. But the Amex opinion otherwise would require, as I read it, simultaneous transactions, and that's just not the case in the original US v. Microsoft case. So you wouldn't have to worry about that particular problem. And it's really not at least as I read the opinion, not a transactions market to start with. So I don't think the court should have similar problems or any problems, even though it would be adjudicating the case today. I have other comments about that, but I want to go back and take my short amount of time and tell you about what it was like to be at the Antitrust Division as I was there as chief economist in 1998 and 1999. And when I went to Washington, I thought I would be doing the usual things one does, but in fact, my role turned out to be a little bit different. And I'm going to tell this story, a story in the time I have, noting that the work that was done in that case was done in the front office with the leadership of Joel Klein and close work with Doug Melamed, and also the work of an incredible team of talented lawyers led by Phil Malone when it came to doing the trial work. But I'm going to describe this from my point of view, just because I think it's been 25 years, and I think it's okay probably for me to talk a bit about the internal workings of the Justice Department during that period of time. So when I go to DC, I'm now going to tell the personal story. I go to DC, and I'm thinking I can't work on the Microsoft case because I had actually been Microsoft's expert in Apple v. Microsoft, the copyright case, and I knew everything about Windows, you could imagine, up through Windows 95. But Microsoft knew me well, and they said, it's okay, we'll allow you to work on the case. That turned out to be a mistake, because as I started to learn about the case, I decided there was really a problem. And I started by doing this by traveling to Silicon Valley a couple times and having secret meetings. I did not know when I was the economist I was going to be essentially working like in a spy network, because none of the folks I met with wanted to be known publicly. And in one case, I had to agree to work in code and meet often secret in a hotel here or there without anyone knowing about it. So I was certainly in the middle of the spy network. And as I went to Silicon Valley and heard lots of complaints, some of which I thought were not very relevant, others of which were quite telling. And what caught my attention was there were descriptions of conduct that fit in my bill the kind of exclusionary conduct that should be relevant, should be discussed. But it wasn't clear to me whether we should be talking Section 1 or Section 2 at the time. But as I learned more and more about the complaints, some of the ones I thought were compelling, I started to think there might be a Section 2 claim here, because there are a lot of different kinds of conduct that all I would describe as exclusionary. But the question in my mind was, do you put these all together in what immediately became kind of a monopoly broth kind of point of view, which I think is one of the tensions in the case. I found it compelling, and still do find it compelling, that you can accumulate a number of kinds of acts that are anti-competitive in a way that makes sense under Section 2 as a monopoly broth kind of argument. The other thing I got to thinking about as I heard about all these kinds of problems was what's the real anti-competitive problem? And the case, as I think you all know, the case was really an innovation case, not a classic pricing case. I thought a long time about how to put forward an innovation case when courts are when it's very difficult to deal with the economics of innovation, with whether we should follow Arrow or Schumpeter or other authors who are worried about innovation, and what to do about pricing. Well, pricing is a difficult issue because, as Dick Schmalensky pointed out in his testimony, Microsoft was not maximizing its profits in the short run. They were not setting the immediate profit maximizing price. They clearly had, I think, correctly analyzed what to do over the long run to maintain its monopoly power, and also how to exclude competitors. So I made the decision not to pursue pricing, and in fact, there's very little analysis of pricing when the case was brought, even though the case, it should have been irrelevant because the case was about innovation, not about pricing. I also came to the view that we had to think hard about how to handle exclusionary conduct. And within the eternal deliberations of the Justice Department, under the leadership of Joel Klein and work with Doug Melvin and others, I came around to the view that we had to pursue a Section 2 case. And that was one of, I believe, at least 4 Section 2 cases that we pursued when I was at the Justice Department. When we pursued that case, we had to focus on whether there was really monopoly power, and the key to that was how to deal with barriers to entry. And the decision was, after a lot of thought, we came around to the view of what eventually became the applications barrier to entry. What's interesting about that, and following on what Steve just said, interesting about that was that the concept of the application barriers to entry had been developed by a number of authors, some of which Steve mentioned. But we did not think that Microsoft in the trial would be very happy with that. But as the trial developed, as the case developed, the ABA, the applications barrier to entry, became the coin of the term, of the word of the world. And Microsoft was talking about it in their defense. The judge started to use the term, and it became a popular term during the trial. That was really important from my point of view as we were putting together the case. Basically, the case became a monopoly maintenance case that we've all heard about. And it was a case in which we have heavily emphasized the barrier to entry, and we heavily emphasized the various kinds of exclusionary conduct. When the case went up to the D.C. Circuit, as was described earlier, we were fortunate enough to have 2 judges, Judge Ginsburg and Judge Williams, who actually were quite literate in economics, and I think they played a big role in the writing of the opinion. Although I've never gotten Judge Ginsburg to tell exactly what he was thinking at the time, but it turned out that they played a big role, and as did Harry Edwards, my NYU colleague, who was chief judge at the time. So. There were a lot of fortunate things that happened at that point in time. Fortunate because there were talented lawyers who put together the case, and fortunate for me because my boss, Joel Klein, was quite happy to have me traveling out to the West Coast from D.C., having all these spy-like secret meetings. And to this day, I still am honoring my promise not to reveal some of the meetings I had, even though they led to some of the folks testifying at the trial. What was for me a very ordinary what I thought would be an ordinary time at the Justice Department turned out to be a very unusual time where I was working as a secret spy. And, uh, and so I'm only today first revealing the fact that I actually was a spy. So I will stop there, and I'll be happy to talk further about the comments. But other than to say that for me, my time at the Justice Department was an amazing time where I learned a lot about how to teach antitrust law and economics, and also became to appreciate the great workings of the Justice Department. So I wish them the best of luck on the current cases going forward. I'll stop
Indeed.
there.
Dan, thank you very much. Eric?
Great. So I'm going to argue that Microsoft is really a model of how courts should account for the economics of platforms. And I say that because I think it avoids a number of pitfalls that we can see even in some very recent cases involving platforms. So I want to mention a couple of them if I have time. So the first is what I would describe as sort of overcorrecting for platform issues, sort of changing things up in an extreme and unnecessary way. And here I'm going to talk mainly about Amex. And the other sort of pitfall is that there are lots of examples of some courts evaluating platform conduct using sort of old formalistic doctrine that is really divorced from economics. And that, I think, is a troubling trend. So let me start with the first point. So this idea of overcorrecting for platform issues. So Amex, of course, has this very strong view on like what we need to do when we are, looking at conduct by two-sided platforms, which is that you have to define the market in a way that includes both sides, right? Technically, this is just for transaction platforms, but I'm not going to keep repeating that. So you can think of this question as sort of like under the consumer welfare principle, who counts as a consumer? Like whose welfare has to be counted? And so the court is saying both. And so a corollary of this is that you automatically have to do balancing of like costs and benefits between the sides. Like if one side is harmed and the other side is benefited, to make a prima facie case, you have to show a net harm, right? So I think that that's a problem mainly for administrative reasons, but I also think it was simply unnecessary, right? That's why I say it's sort of an overcorrection. So I think the confusion starts with this language that was all over the place during the case and even in the opinion. This language says, well, in a two-sided platform market, you have to consider both sides. In other words, don't ignore one side. But this is really a straw man because nobody thinks we should ignore one side, not even the district court whose decision was overturned. He was actually very explicit that you need to consider both sides. Okay, so look, at a general level, it's completely right that you need to consider both sides, but it's just that doesn't require what the court says that it requires, right? Which is this two-sided market definition and balancing, right? So what you have to do in a two-sided market, so first of all, what's special about them? Well, each side, your sort of, the value you get from the platform depends in part on the number of users on the other side, right? So like, let's talk about an app store. Like, I don't just care about the prices, like the fees that I pay to buy apps. I also care about like the quality and diversity of apps on the platform, right? So imagine that we define the market to be just the consumer side of an app store. And it's easy to see that like, yes, you can account for both sides within this framework. So suppose that like the Apple, implements some restraint and this raises prices that consumers pay for apps. Okay, well, if this restraint also increases the number of apps or their quality or something, then that could, that could mean that consumers aren't actually worse off, even though they're paying higher prices, right? Because this affects their welfare as well. So that's the sense in which, you don't need this two-sided market definition, right? What you need to know is not how does it affect the welfare of the other group, but how does it affect their behavior? Does it lead app makers to put more apps? Does it lead more apps to be on the platform, higher quality apps? And that change in behavior affects the welfare of the first group, the one around which you defined your market. And so like one easy way to see that this is, a completely reasonable way to approach this is that this is what we already do when it comes to like resale price maintenance and restraints like that, right? So think about the classic story about why we think resale price maintenance can benefit consumers even though it raises prices. Well, it's because it affects the behavior of retailers. in a way that promotes sales of the good. It increases retailers' incentives to do things like carry the product and market the product. And so we think that because of that shift in retailer behavior, you end up with a welfare improvement among consumers, right? We see that like because we think output goes up, right? Maybe it's not always true, but that's the story, right? And there's some logic to it. But of course, when we're telling that story, nobody says, well, we need to define the market to include consumers and retailers. And nobody says we need to like balance the benefits to retailers against the harm to consumers, right? Nobody thinks that. Nobody thinks that's necessary. It's really the exact same. We should have reached that same conclusion when it came to two-sided platforms. So the other problem that I think Microsoft avoids is sort of falling back on formalistic doctrine that really isn't helpful, right? So the spirit of Microsoft is very much like anti-legalistic doctrine, right? It's very much like, let's think about the economic realities. But there are some, conspicuous parts of Section 2 that are not like that at all, that are extremely formalistic. So, so just to sort of set this discussion up, I want to note that like a lot of the antitrust controversy surrounding platforms right now involves essentially the same concern that came up in Microsoft. We're worried that there's this firm who's exploiting a dominant platform to exclude rivals, not in the platform market, but in some adjacent market, right? So in Microsoft, you've got your operating system monopoly, and you're using that to exclude browsers. And at least for now, we're not thinking of those as competitors. We're thinking of that as a separate market. So the difference is that a lot of the more recent examples of this involve purely unilateral conduct by the platform, right? Whereas Microsoft involved a lot of agreements. And this is going to affect the rules that courts apply in, I think, problematic ways. So a good example is the FTC's case against Facebook. So the original complaint included this allegation that Facebook withholds APIs from competing app makers. Right? So I just want to focus on one part of that, which was that Facebook withheld APIs from competing messaging apps, which prevented the messaging apps from interoperating with Facebook's social platform. Right? So I think it's clear that the theory of harm here is really the same as in Microsoft. The concern is using your dominant platform, which is the social platform, to exclude rivals in a separate but complementary market, messaging apps. Right now, I'm not claiming that the case for liability was as strong in Facebook. I don't think it was. Maybe there should have not been any liability for this. The problem that I see is that we are applying wildly different rules to these two sets of cases that, from an economic standpoint, are really raising the exact same concern. Right? So in Facebook, you would think, well, the theory of harm is the same, so we should probably apply a similar legal standard. Like we should ask similar questions. Like in Microsoft, let's ask about foreclosure and potential justifications. That's not what happened. What happened is the court said, I declare that this is a refusal to deal, and now we're going to apply Aspen. And then nothing looked like Microsoft at all, right? So it was this, before I get into Aspen in more detail, let's just note, in case you've forgotten, Aspen is this sort of funny old case about neighboring ski resorts whose owners hated each other. By Section 2 standards, these are very tiny businesses. And it's just sort of a weird case with kind of funny facts. And it's hard. I don't think there's any antitrust decision that tells us less about platform economics than Aspen. So the idea that that case is now controlling a big segment of platform conduct is really, that suggests the state of antitrust is not in a great place right now when it comes to unilateral platform conduct, right? So anyway, under Aspen, it's, courts apply this sort of test where they say, was there prior voluntary dealing between the defendant and the rival, and did the defendant sacrifice profits? So one thing to notice about this test is that, it doesn't actually ask about the effects of the defendant's conduct. It just asks about the defendant's intent. But this is kind of a waste of time because intent is not the thing we care about. We care about economic effects, right? We want to know, would antitrust intervention make the world better? That's what we care about. So when you think of it that way, making intent a prerequisite for liability really doesn't make sense, right? We're not in the business of just policing intent for the sake of intent. So Microsoft understood this. So Microsoft says, here's the quote, "In considering whether the monopolist's conduct on balance harms competition, our focus is upon the effect of that conduct and not upon the intent behind it." Right? So, the point I'm trying to make here is that courts are drawing this very formalistic distinction right now between practices that are basically equivalent, or at least very similar from an economic perspective. They differ in the fact that one of them is unilateral and it falls into this doctrine, refusal to deal doctrine. And once you get into that refusal to deal doctrine, it's like economics is dead from that point on. And it's just this sort of old-fashioned test that's just, completely mapped onto the facts of Aspen and has very little to do with economics. That's not a good place for us to be, given that, much of what platforms, many of the cases that we're looking at in the platform space involve unilateral conduct, right? So I think I'll end there.
Great. Eric, thank you. Michal and Raz.
Thank you. Sorry, the other way around. Okay, so this is a paper that we wrote for this conference, and it focuses on Microsoft's treatment of network effects, which we term the Microsoft formula for market power. And specifically what we do is we draw on cutting-edge tool from network science to uncover some of the formula's oversimplifications, focusing on the role of highly connected hubs that operate on the platform in maintaining the platform's integrity. Sorry. So what the Court of Appeal, framed it as follows. It said, in markets characterized by network effects, one product or standard tends towards dominance. Once a product or standard achieves wide acceptance, it becomes more or less entrenched. Competition in such industries is for the field rather than within the field. So, in short, what you have to prove is substantial market share together with network effects, and you get entrenched monopoly. It's a very simple formula. Now, this formula has a lot of allure. It's simple. You have to ask two very simple questions. Are there network effects, and does the platform have substantial market power? It's applicable across industries, and actually it was applied to many different industries. It yields an unequivocal conclusion of platform market power. Now, of course, courts look at other factors as well, but network effects are heavily relied upon to establish market power, and oftentimes other elements, such as switching costs, for example, are related to network effects as well. Sorry, I keep on going. Okay, so these are just a few examples of cases where you see this kind of extreme formula in use. Network effects conferred to Realcomm substantial market power and made successful entry by a rival improbable. And you even see it on the other side of the Atlantic. And the Google case brought by the EU, indirect network effects create black oceans, which make competition with Android impossible. Now, what our research tries to argue is that this formula is simplistic when hubs are present. So what we do is we use insights from network science. And we tackle one simplistic assumption of Microsoft, which is that all platform participants are comparably valuable to the platform's network effects and its integrity. And we show that since it's not true for most networks, there is an element that is missing from the from Microsoft formula.
Okay, so thank you. It's an honor to be here. And now that Michal has set the stage, it's my role to give you a taste of what network science brings to the table. So, empirical observations reveal that many networks, not all but many, have hubs. Hubs are nodes that have orders of magnitude more links than the average node in a network. Consider Facebook. I have 800 Facebook friends, something like that. Didn't check lately. But Cristiano Ronaldo, which even Americans should know about, has over 170 million followers, right? So Cristiano Ronaldo is one of the largest hubs on Facebook. And, sorry, premature? Mm-hmm. Okay, so why should you care? Well, the presence of hubs is critical to a subfield in network science that is called network robustness. Network robustness asks, what percentage of nodes do we need to remove from a network in order to break it? And to illustrate this, we're going to show now with these animations 2 node removal processes. So on the left, we're going to take nodes at random and remove them from the network gradually. And on the right, we're going to target the hubs. We're going to take the largest hub, then the second largest hub, and so on. Boom. These are, of course, identical networks. And you will see that hub targeting is way, way, way more effective. Now, you might say, well, these are very small networks. But the principle holds for enormous networks encompassing millions, if not billions, of platform of nodes. To break a scale-free network with hubs using random node removal, you need to remove nearly all nodes. And to break it using hub targeting, you need to remove somewhere in between 5 and 15% of the hubs. Okay. So based on this insight, I've coined in previous work a term, hub plucking, which describes competition over hubs between platforms. And you need to understand that when you remove a hub from a platform, it's not only that you remove the hub. You remove the hub and its followers may follow, inducing more hubs to live, inducing more followers to live. And this is called a cascade in network science. And based on this, I've termed hub plucking, and this competitive strategy actually happens. So this is a quote by Twitch's CEO and co-founder, and he explains how they breached through the network effects moat that safeguarded YouTube in roughly 2010. So YouTube used to have a 95% market share in video game streaming and a very solid market position in general streaming. And if the Microsoft formula would have been correct, they should have had no hope in breaching through because they had no revolutionary tech, they had no ample resources. But what they did, they hub-plucked YouTube. They convinced influential streamers to jump ship through exclusivity agreement or at least to multi-home. And they even usurped YouTube for a while until YouTube struck back. And today they fight with one another over influential streamers. Okay, and there are other industry examples. So this means that the network effects moat has some sort of an Achilles heel. And you don't need to convince all platform participants to live. Okay, so based on this, we can take this even further. So beyond facilitating inter-platform competition, there are intra-platform dynamics. Since the platform depends on the hubs, it cannot afford to fight with the hubs. And the hubs can push back against certain platform power abuses. And in an upcoming paper, Michal and I also examine the reverse, which is the hubs will use their power to abuse other platform participants. And of course, the platforms cannot intervene effectively. So we invite you to read that upcoming work. But the key takeaways for our purposes are that the Microsoft formula doesn't account for hubs, which again exist in many, many, many platforms. And because of that, it overlooks hub plucking competition and the ability of hubs to push back against platform power. And what we propose is to revise the Microsoft formula to account for hubs. And you can think of various legal mechanisms to do so, one of which is a burden shifting framework. If there are hubs, the burden will shift, etc. So thank you.
Okay, thank you. Dan has some points he wants to make, but let me get a first question in, and then, Dan, why don't you make the point, and then I'll follow with the question.
Yeah, I was just wanted to add a little bit more about the history that was relevant. First of all, there was a lot of interesting discussion within the Justice Department about whether how we should pursue Microsoft's conduct. And there are a couple lessons here. One is we were aware of certain kinds of conduct, as I said, that we thought was exclusionary. We thought it was very clear that there was a Section 1 claim that we could pursue. and that would have been what I would have thought of as a small case against Microsoft. But we were not aware, there was conduct that I was aware of just from the work I had described previously. And we had a very interesting discussion internally, and we argued, I argued, and others argued that we needed to file our case because until we filed, we would not be able to get the court to allow us to pursue some of the practices that I thought were anti-competitive. And we filed the case, and we filed the Section 2 case, and it wasn't until we filed that we got access to a lot of the materials, internal emails that Microsoft was sending around and so on. So there's a lesson there. Sometimes you actually need to be in court to get the court to allow you to do broad analysis. And the second thing that was important to me was what the right legal standard should be. And we decided to take the most difficult standard and put it forward, which was basically a version of the no economic sense test. And we thought we could win on that rule by the court, partly because, as we've heard previously from David Boies and actually from Eric, there was really not much defense that would be opposed to that standard because Microsoft was not really putting forward much of an affirmative defense at that time. Now, it's important to me that the DC Circuit did not pursue that standard. They put forward a balancing test. From the point of view of the folks that do economic testimony, it's a very difficult test for a court to handle. Courts are just have not really handled balancing tests, and at least in a lot of the cases I've seen over the years I've been involved in this world. And so we're in a world of trying to do balancing tests where it's extremely difficult. And I'd just like to hear what others think about that, but that's a concern I have.
One note on that observation, David Seidman, who I worked with along with Greg Worden at the Antitrust Division, who were very helpful to me always. David, out in the hallway before this panel, we were discussing the no economic sense test. And it's always a question that I've had, I think others as well, about how we're supposed to read the DC Circuit's opinion, because in the district court, David reminds me, the no economic sense test was the test that was pressed hard, and frankly, a lot of what Microsoft did was fail to offer any explanations for a lot of its restraints that made any economic sense. And in the DC Circuit, the court doesn't do a lot of work on a lot of those restraints because the court basically notes that there's really no pro-competitive justification even offered here. So I wonder how much we can read the DC Circuit's opinion on its own, or how much to understand, the theory of monopolization that Daniel was asking for, we really have to go back to the district court opinion, and in particular to the government's briefs and how the district court responded to them, which I think, a lot of which was shorthanded in the DC Circuit opinion. So I'd be interested in anyone's thoughts on that.
Yeah, the no economic sense test, Greg has always pretended that it's the main test, but it's actually a second test. After you prove consumer harm, you then need to prove that it makes no economic sense. And so it's going to make it harder. Basically, no economic sense is an intent test. And the way it's been, I think the opinion's been somewhat mischaracterized because, some people, Mark Popovsky for one, says, well, there was really no balancing that got done. As long as Microsoft asserted a defense, they won because justice never showed that the harm exceeded the benefit. But there was one area where they did balancing with respect to the boot up sequence.
Yeah.
So you can't say that they never did balancing. But I agree that the way it's been interpreted has basically been, if you go back to Alcoa, sole purpose to exclude. If you go with Microsoft appellate court and, Doug Ginsburg's very careful to say the words really matter. So this idea that plaintiff needs to demonstrate defendant only needs to assert is very important. And if you then put it back on the plaintiff and it's hard for the plaintiff to show, then you're left with what amounts to, if there's any plausible efficiency, the defendant wins, which is what Learned Hand called sole purpose to exclude. And Justice Gorsuch, that's his standard, that's his interpretation of Aspen. That when you get right down to it, Aspen didn't do a balancing test, notwithstanding what they said, they really did sole purpose to exclude.
Yeah, so the quote I mentioned from Microsoft where they said, it's not intent we care about, its effects. Right after that, the court says, intent evidence is relevant only to the extent that it sheds light on effects, right? And so I think when, I don't necessarily think Microsoft forecloses the no economic sense test. I think it takes the position that if you already know that there are harmful effects and there's no reason to think that there are good effects, then there's nothing to balance and we're done. But if you think that there really is both harm and a plausible efficiency, then you might want to ask about intent, because if it seems like the defendant really that it's really a pretextual justification, then you can avoid having to try to actually balance as well.
The problem with that is suppose you've got an innovation that costs $3 a unit, but gives value to consumers of $5 a unit. So it's let go through under the no economic sense test, but it raises barriers to entry that allows the monopolist to raise price by $50. So basically, $5 benefit, $50 harm.
So
If you're applying the no economic sense test as a second test, the defendant wins that case.
So I don't think you have to view it as a mandatory test, just as one way of ruling out the need to balance it all. If you can say that, like, that Microsoft's intent is just to exclude, then you assume then,
No third step.
yeah, there's nowhere else you need to go.
There's nowhere else to go. Okay. Michal and Raz, I want to put this question to you. It's related to your paper, which I want to ask you about the application of in a moment. But, it's been almost 25 years now, and I'm interested in your assessment of whether what changed circumstances suggest about the application of the economic principles that we've been talking about in the Microsoft case. So let me just give you an example. So one of the restraints was the boot up sequence, which Steve just mentioned. A related restraint was that Microsoft agreed with OEMs that they wouldn't feature another browser's icon on the desktop. And with respect to that second one, the story there about how that erected a barrier to entry was that it would be very difficult for a competing browser to get any share, because that was the way that browsers were distributed. That was a significant way, or maybe the most significant way at the time, in which browsers were distributed. So now, like, you download, everything's in the cloud, and you download things, and it just doesn't seem like that argument would run anymore as a matter of technological reality. But does that suggest something about the economic theories themselves? Does that suggest something about what the disposition of antitrust should be toward the likelihood of technological change? What are your reactions to those questions?
Well, let me start. I think that a lot of the basic principles of economics that were used in Microsoft are actually applicable today as well in many of the cases, whether it's Google or other cases that are now brought to trial. So it depends on the level that you're going to. If you're going to the macro level, for example, exclusivity, some things are distributed and are easily, but others are not. So it really depends on bottlenecks, where they exist, what the distribution is there as well. However, some of the economics, what has changed, I think, part of what has changed is not only our knowledge, but the tools that we have today to understand the world. So, for example, network science together with data science provides you with technological tools that allow you to analyze better how markets might react. And I think that we should use them.
Well, for example, in your paper, you talk about large nodes in a network and
Right.
the ability of large nodes to push back against extraction by a network, a platform monopolist. So under what circumstances would you expect that? So I wouldn't have expected that in Microsoft because that network wasn't particularly dependent on large nodes. So when would we expect it? Even in a large node network, under what circumstances, if you can generalize, would the large nodes have any incentive to coordinate and push back?
Okay, so first of all, it depends if there is a rival platform at play or only a potential competitor. How large is the hub? How many hubs are there? How easily the hub can switch platforms in terms of costs. Many elements go into this, and we analyze them. I do want to go back to the previous question. I want to say that part of the problem, not with Microsoft itself, but with the case law that followed, was that we treat economic theory that is supposed to describe the facts as legal principles. And the technology changes. So the World Wide Web was born in like the early 90s. That's roughly, the licensing middleware cases. Computing memory was very different. You couldn't afford to have more than one browser on your computer because you only had like 200 megabytes or something like that. So the reality changes, and so we need, we need to adapt both with the tools in how we assess and examine the dynamics, but also with what are the facts on the ground. And I think that the facts of Microsoft are not true, are not applicable to most major cases going on around the world right now, vis-a-vis GAFAM, etc.
Okay, we're close to our time, so I wanted to open up this panel up to questions from the audience. So please, if you have a question, now's the time. Not possible. Someone must.
I have a question to Eric.
Yeah, go ahead.
Is that okay?
Yeah.
Yeah, Eric, I'm going to ask you, I mean, I would love your opinion on one of the questions that Michael Hausfeld asked David Boyce this morning. And he said, when you have a two-sided platform, and I mean, what kind of standard do you think should be applied with regard to consumer welfare? Do you think that we should only allow conduct that in which all consumers are well off, or would you allow some trade-offs, or what would you do in a situation, for example, where consumers are on one side are harmed just by a bit, but consumers on the other side are benefited by a lot?
Yeah, it's a great question. So I think there are three options that are worth considering. And the one that I think is definitely wrong is the one that the majority picked. Under that rule, you have to balance the effects between sides just to make a prima facie case. Okay? An alternative that allows you to still balance effects but makes it more tractable is what Breyer suggested in his dissent, where he said, okay, look, you should be able to make a prima facie case by showing harm to one group. So in Amex, that would have been merchants. And then the burden shifts to the defendant, and he has to prove that there's a countervailing benefit on the other side, right? So then you've allocated the burden in a way that looks like what we normally do, right? Like the countervailing argument, now the defendant has to prove that. The plaintiff has to show like the bad part of the conduct. And so I think that that's reasonable. I do think you're still going to run into this question of like, it overlaps with the question of like, how do we think about out-of-market efficiencies, right? Because under Breyer's suggestion, we are defining the market to subsume just one side, and we're potentially allowing you to invoke benefits to a different group, hence out-of-market benefits. I think that's a hard question, I don't have a super strong opinion on that. I think it's reasonable minds can differ. I think what's important is that at minimum, you have to divide up this burden so that it should be sufficient for a plaintiff to show harm to one side, and then the defendant should have to show a countervailing benefit to the other.
The way Daniel and I looked at it in our Amex article was exactly that way. And then we said there are a variety of ways, to answer McCall's question, of how you might balance. I mean, you might put more weight on the effects on the people in the primary market, the harms to them, than the benefits elsewhere. If you're going to look at the benefits in the second market, you also have to look at harms in the second market. You can't just look at one. And then there's the question of what other markets? That's the hard part. Once you start to balance, where are you going to stop?
That's right.
Dan.
Yes, I was going to go back and talk about what we learned about intent in the case. One of the things that was unusual about the case was we had access to many emails that were sent by Microsoft, because that's the way Microsoft operated, and the emails were very honest, as I saw it. And so, as we read all these emails, we came to the conclusion that there really was a clear evidence of intent in that case. But it's not something you would see as much today, because firms have learned now to be very careful about the emails they send around. And so I think
Or
it's much
destroy.
harder. Or destroy, that's right. The world has changed partly as a result of what happened in that case. The other thing that was unusual is that there was a big battle about market definition, which I thought should have been largely irrelevant. But Microsoft argued that the market went way beyond PC-based operating systems to include operating systems from small handheld devices and from mainframe operating systems, which I always thought at the time was a ridiculous argument. But they pushed that very, very hard. And it was very, very harmful in that case. Very harmful to try to convince the judge of something that really made very little sense when you thought about it. And so the judge did get the right analysis of market definition. And that, by the way, the working in the trial part of the case, which David Boies talked about, was difficult because, believe it or not, neither the judge nor the lead lawyer for Microsoft nor David Boies actually worked with computers. They were computer literate, but they actually did not use computers. So you had three key people who actually were not people regularly using computers at the time. So it took a while to educate the judge. And that was actually part of our case when we were trying, was try to find ways to educate a judge who was a very conservative judge and a judge who knew very little about either economics or about how computers operated.
Yeah, I just wanted to add one thing about intent, and that is the McWane case, Andy Gavel reminded me, has a large section of intent. They reject the Microsoft approach. And the 11th Circuit judge says, Microsoft tells us not to really look at intent, but my God, the intent documents in this case and in the testimony were just so clear that they had the intent to destroy competition.
Yeah, and I often show my students the intent documents in the Whole Foods merger, and the students, to them, it just jumps out at them as like any fact finder would want to know about these. Michal?
Yeah, just a word about intent. I think that as we're moving into a world where many of the decisions are made by algorithms, whether, Section 2 cases or Section 1 cases, it doesn't matter. In such a world, we have to rethink all the cases, I think, that use intent. We might define it differently, or we might do away with it. But if we leave intent there, then we're going to run into a lot of problems with dealing with where we are today and where we're going to be in a few years.
Yeah. Rebecca had a question.
Rebecca?
I guess I wanted to push one more time on Eric and the two-sidedness thing. Because when you started describing the two-sided market where actually we sell price mechanisms to each other as a two-sided market, it kind of all be analyzed the same way as a two-sided market. It all kind of fell apart for me. So I guess, and then I was thinking about labor. Oh, okay. This will give me a chance to reframe my question in a more coherent way. Is it a two-sided market? Isn't everything a two-sided market according to your definition, as long as we look at kind of the inputs as one side and then the end product as the other? So for example, Alston could be seen as a two-sided market in the sense that, so you have harm to the players over here by colluding to give them a zero wage. But hey, it's great for football fans because they like watching people who are amateurs play. And I guess the part that fell apart for me when I was thinking about it that way is, why would we be doing any balancing? I thought that the antitrust laws said you can't do this, you can't do monopsony, you can't do, Weyerhaeuser or whatever, and you can't do monopoly over here. how, would we be balancing those things now?
Right,
According
so-
to your framework?
Yeah, so I actually wasn't thinking that RPM like is a two-sided platform. I was just thinking that that's a situation where a restraint affects a group of agents who are not like consumers in our relevant market. And that change in their behavior feeds back and affects consumers, right? And so like in an RPM case, price goes up, but we still think consumers might be better off. And it's because of how the restraint affects retailer behavior. Okay, so I'm saying if you define it in a two-sided market, you make your market defined around one side. It's sort of the same story that you can tell, that the restraint affects the other side and will lead potentially them to participate on the platform more. That will come back and affect the welfare of the group that is in your market. That's the point I was making.
Oh, yeah, but that, okay, so I understand that, but that doesn't get to my question, which is then, so now that, what I would say is what you've just made it is into just like one market, right? The market is the consumer of the thing. Is the thing you're doing on the other side good for consumers, bad for consumers? But then later, which I think is fine, and that all holds together much tighter than the actual Amex opinion, of course. But then later you said, well, maybe we should be balancing effects on one side with the other.
Right.
And so isn't it then always true, you know, that a monopsonist could be breaking the Sherman Act over here as a monopsonist, passing it through maybe to this consumers, and now what we balance those things? That's what
Yeah,
I'm
so
asking.
no, that's totally right. So I actually mentioned when I was talking about balancing that there are like three options. The one I didn't mention is that you just don't count the welfare of the welfare effects on the outside group, right? Which is like what we already do in merger cases. I think I actually favor that. The reason I favor it is both, now if you allow balancing in the two-sided platform context, there's, I think by the same logic, you would also allow it in all these other contexts. I also think that courts can't really balance, and like even the experts too. It's like, it's not an easy thing to do. And so courts end up doing things like they'll find some other way to end the case so that we don't have to balance, and that it's not really productive to pretend like we can balance if we can't actually balance. So I would, if it were up to me, I would probably not allow that kind of defense, but I think it would still be more reasonable than what the MX court did.
You know, ironically, in the issue of workers, courts, a lot of courts in the past would say it's okay to hurt the workers if you help consumers, that they privilege the consumer side. So there's cases where they colluded to actually, you know, horizontal collusion to harm the upstream, and the court says, oh, it's okay because it's going to lower the price of hamburgers. And so this Deslantis case, having Frank Easterbrook say, no, you can't do that, that you have to, if it's harm to workers, you can't defend by saying it's going to be a lower price. It was literally McDonald's case, that you can't defend by saying there's going to be a lower price of hamburgers. That's really significant. And in Alston too, I mean, Kavanaugh's concurrence, saying you can't, you know, even if people like want to see football played by slaves, you just can't do that.
Yeah. Michal, your last word, please.
I think that this is going to be a really important question. It already is. Just think about an algorithm that can engage in the price discrimination, in personalized prices, okay? And think about a market that has a lot of segments so that some consumers get higher prices and some do not. So some are better off, they get lower prices than they would have otherwise, and some get higher prices. And this is the reality, okay, with many firms today. The question of how we balance is going to be a really important one. I think we cannot I think we should think deeper about it, and Dan and I have written about it a bit in our paper about mergers and AI.
Okay, thanks to everybody very much, and please join me in thanking the panel.